Welcome and thank you for attending today's webinar and CLE course hosted by the Arts and Business Council of Greater Nashville, the Copyright Claims Board, and the Copyright Office. Today's webinar, Copyright Essentials for Artists, Musicians, and Creatives, an overview of the Copyright Claims Board and Copyright Office resources, is a part of our monthly education series. If you'd like to follow the Arts and Business Council on social media or sign up for our email newsletter, you will receive updates for when future webinars are announced. For anyone on the call who would like to use closed captioning, you can activate the live transcript feature through Zoom, which we are using to provide automated transcription for today's panel. Closed captioning can be activated through your Zoom menu. Look for the closed caption logo or the words "Show Captions" to activate live transcription. I also want to remind everyone that this session is being recorded. We will share a link to the recording within 7 to 10 business days after the webinar. My name is Kate Formway, and I am the Volunteer Services Specialist at the Arts and Business Council of Greater Nashville. We are an independent 501c3 nonprofit that leverages and unites the unique resources of the arts and business communities to create a thriving, sustainable, creative culture in Tennessee. We do this by providing education, resources, and opportunities to the creative community while connecting the business community to the arts to foster workplace creativity and innovation. When you become a member of the Arts and Business Council, you join artists, art lovers, creative organizations, and leading Nashville area companies in cultivating our creative community. Follow the link in the chat to learn more about the benefits of membership. ABC's flagship program is the Volunteer Lawyers and Professionals for the Arts, or VLPA, which is a referral service providing pro bono legal assistance to income-qualified artists, arts organizations, and creative businesses in Tennessee. VLPA services include our monthly Black-owned small business and nonprofit legal clinic with our partners at the Bradley Law Firm. Nashville area small businesses that are at least 51% Black-owned with less than $1 million in annual revenue are eligible. The September clinic is almost full, but there are still appointments available. Follow the link in the chat to secure your spot. Don't miss Periscope Pitch and Artist Entrepreneur Showcase, September 4th from 6 to 9 p.m. at Oz Arts Nashville. The talented members of the Periscope Artist Entrepreneur Training Class of 2024 will put their training to the test as they showcase their work, unveil their business plans to the public, and take the stage to pitch their creative businesses to the Nashville arts and business community. RSVP today at the link in the chat. And with that, I'm excited to turn the session over to today's speakers. I'd like to give a warm welcome to Jessica Chinadurai, Attorney Advisor in the Office of Public Information and Education at the U.S. Copyright Office, Monica McCabe, Copyright Claims Officer for the Copyright Claims Board, and Whitney Levandusky, Supervisory Copyright Claims Attorney for the Copyright Claims Board. Thank you all for being here today. And Jessica, I will let you take it from here.
Thank you, Kate. And I am just going to share my screen so we can all take a look at our PowerPoint together. Great. Well, thank you so much, Kate, for the warm welcome, and welcome everyone to today's session with the United States Copyright Office. As Kate mentioned, my name is Jessica Chinadurai. I'm an attorney in our Office of Public Information and Education, and I'm joined by my colleagues Monica McCabe and Whitney Levandusky, both of whom are with the Copyright Claims Board, which you will hear us refer to as the CCB. So today we'll be giving you a little bit of background on copyright law, including some foundational concepts just to kind of set the stage. And then the CCB will dive into their work and key takeaways for you around the CCB processes. And then I will close out by taking kind of a larger look at the Copyright Office, including other duties that we have and all of the wonderful resources that we have available to you as well. So with that, let's start with some copyright basics here. So copyright law has a deep history dating as far back to the Constitution. The language that you see here in the gray box is what's known as the Copyright Clause, which talks about copyright promoting the progress of science for limited times by securing exclusive rights to authors. The language is part of a greater intellectual property clause or IP clause, which includes or discusses patents as well. So the United States Copyright Office administers copyright law, which is found in Title 17 of the United States Code, and it protects many types of works. In general, copyright protects original works of authorship fixed in a tangible medium of expression. So that's what you see broken down here on the slide and what we'll break down for you in just a minute. First, you must have a work of authorship, and that work must be fixed and original in order to have copyright protection. So looking first at what it means to be a work. What is a work? So Section 102A of the copyright law provides a list of categories of works that are copyrightable subject matter. This list includes the type of works that can be protected by copyright, such as literary works, musical works, including any accompanying words. And for this category, we're talking about musical compositions, often in sheet music form, and any accompanying lyrics as well. Then we have categories of dramatic works such as plays, operas, and the accompanying music there. Those works are meant to be performed. And then pantomimes and choreographic works as well. Pictorial, graphic, and sculptural works is a very huge category. You can see here in the parentheticals the various types of works that might fall under this category, such as paintings, photographs, and sculptures. And then separately, we have motion pictures and other audiovisual works protected by copyright. Sound recordings, which are generally recorded sound. It could be music. It could also be a podcast or an audiobook as well. And then lastly here, we have architectural works. These were the last added to the law in about 1990, and they do include the buildings that are habitable as well as their blueprints. So again, kind of pointing to the parentheticals here, you guys can see that these categories are very broad. They encompass many different types of works. And some of the lesser known works that the Copyright Office does receive for registration include computer programs. Those are actually a type of literary work, the source code, as well as fabric and wallpaper designs. Those are pictorial, graphic, and sculptural works. So moving on to fixation, we mentioned works must be fixed in a tangible medium. And essentially what that means is that the work must be written, recorded, or otherwise captured. It has to be captured in a copy, and it must be sufficiently permanent or stable to be perceived, reproduced, or otherwise communicated. And what we mean by reproduced is make copies of. This also has to happen for a long enough period of time. So the law uses the phrase more than transitory, and that's what that means. Now, that could sound, I think, pretty complicated if that's the first time you're hearing about it, but there are countless ways that a work can be fixed, and most works are fixed just by their very nature. Think about if you're writing notes right now on a piece of paper, you are putting that in a fixed form. And really, the key takeaway with fixation for you is that copyright protection begins the moment that a work is fixed. It does not start, contrary to popular belief, when it's registered with the Copyright Office. Copyright protection begins the moment that you have that work and it's fixed and then it's original. So moving on to originality. Originality has a special meaning in copyright law. It has its societal meaning, I think, and then it has its copyright law meaning, which includes two components. What it means to be original in copyright law is that first, there must be independent creation, and then second, there has to be sufficient creativity. So looking first at independent creation, that just means that the work must be independently created by an author. And that work must originate from the author, not be copied from another work. Pretty straightforward there. In terms of creativity, we get asked all the time what this means. And essentially, sufficient creativity requires that the work contain at least a small amount of creative expression. That small amount does have to be more than trivial. It just has to rise above that bar, that low bar that does exist. This comes to us from a Supreme Court case called Feist, where we learned specifically that facts, data in the form of individual names or addresses in a telephone book are not copyrightable. So that's an example of something for you that is trivial. Examples of other content that's trivial includes words and short phrases such as names, titles, slogans. Slogans you might think of, which are protected, could be protected under trademark law, but they are not protected under copyright law for the very reasons we talked about here. Also trivial and not protected by copyright include familiar symbols and designs, including simple geometric shapes like your squares, circles, ovals, typeface or lettering, including fonts, and then mere variations of coloring. So again, all of that content is not sufficiently creative. It does not meet that requirement. And the last point on originality that's always good for creators to keep in mind is that the amount of time or money that you might spend creating something, how successful it is commercially, or what it's intended to mean, those are all things not considered by copyright. Similarly, a work does not need to be innovative. It doesn't need to be presented, in a particularly surprising or unique way. But again, it does have to rise above that low bar. And so it does have to be more than mechanical or routine or what we think of as maybe typical. All right, so switching gears just a little bit to talk about copyright ownership. Who is a copyright owner? It's a really important question as you create works, because initially an author of a work is the owner of the work as well. In most cases, then the author is the person who created the work. So they're going to be, again, the initial owner. In certain situations, though, the author may not be the person who actually created the work. And this comes into play most often with what's known as works made for hire. So there are two parts of the definition of a work made for hire. It could either be a work created by an employee in the scope of their employment. Say you're working for a company and you're an employee, you have specific job duties, and you create something in the scope of that employment, in the scope of your job duties. That's likely a work made for hire. Or the second part of the definition is a commissioned work that fits into one of several specific categories listed in the law, and the parties have entered into a signed written agreement that explicitly states, word for word, that the work is a work made for hire. So I think we got a question before the webinar about whether or not, a certain work might be a work made for hire. And what's important to remember here is that contractual language might determine what we're talking about or what we think about when we look at works made for hire. The contract itself could confirm what work is created as a work made for hire while also explaining or detailing that another work is not. But it all comes down to the exact terminology used in that contract. And so again, to kind of look at the bigger picture here in a work made for hire and authorship and ownership. In the case of a work made for hire, the author is the employer or the commissioning party, as opposed to the person who actually does the creating. So in those cases then too, the employer or the commissioning party is also the owner of the work. And then on the last bullet point here, we just wanted to note that a third path to copyright ownership does exist through written agreements. Copyright can be transferred. It can be transferred in writing from person to person, from business to business, and so on. But it must be in writing in order for it to be considered a legal transfer of copyright ownership. So there are other types of transfers that you guys can keep in mind. We won't cover them today, but for example, you might have received copyright ownership by inheritance, by state community property laws, and by partnership agreements as well. But ownership is really important when we talk about what it means to be an owner. Now that you know who an owner is, let's talk about more of the rights that an owner has. And when you see the word copyright, you might just think to yourself, it's just the right to prevent others from copying my work. But that is just one of the 6 exclusive rights of copyright. So the 6 are listed here for you, and a copyright owner has both the right themselves that's listed here. So that means they can take, they can engage in or take the action directly that's mentioned here, or they can authorize others to engage or take an action provided by the right. So in summary, the 6 exclusive rights include first, the right to reproduce. That means you have the right to make copies of your work. Second, the right to prepare derivative works based upon the copyrighted work. Examples of this include remixes, translations, adaptations, maybe, taking a novel to a movie. Third, the right to publicly distribute your work. That is publication in copyright law, which essentially involves distribution by selling, renting, lending, or leasing. And then the last 3 rights here involve the right of a copyright owner to perform or display their work, or authorize others, again, to perform or display a work publicly. So the works that these rights apply to are listed in the parenthetical, and that's only because there are only certain types of works that can be performed. If you think about it, you really can't perform an architectural work, for example. So that's why there are only certain works that these apply to. And then lastly here, the sound recording right. This is a digital performance right, to publicly perform a sound recording. So the importance of exclusive rights is what you see in this big red box at the bottom here. A violation of any of the rights here is copyright infringement. And copyright infringement generally happens when any one of these rights is violated. That again means that someone is not authorized to take an action listed here, unless, as we've said, a defense applies. And the most common you might hear about, of course, defense-wise, is fair use. But this is an excellent segue, copyright infringement, to talking about the Copyright Claims Board. So I'm going to hand it over to my colleagues, Monica and Whitney, to tell you more about the CCB and the work that they do, especially related to copyright infringement.
Hi, everyone. I'm Monica McCabe. I'm one of 3 officers on the Copyright Claims Board, which was established under the CASE Act back in 2020. And since then, we've done a lot of things to set the board up. Tribunal, we've hired staff, we've created our docketing system, we've created a website, et cetera. And then we opened our doors to accept claims. What is the CCB? It's the first ever small claims tribunal in the United States. And it's meant to help artists that have works that are not, $1 million type works, right? We have a limited amount in terms of damages that we can award, which I'll go into a little bit more. And why, people wonder, well, why were we created? The problem was that if you had a copyright infringement claim, you had to go to federal court, which ends up costing quite a bit of money. If you're a company or a small, business, you had to have an attorney handle it. You could not represent yourself or have an employee represent you. So because there wasn't a lot of money to be made, few attorneys were willing to handle small claims. And then a lot of small owners felt that it wasn't worth enforcing their rights because there was, the filing fees, the attorney's costs and everything were so large in federal court. Sometimes accused parties like the defendants felt pressured into settlements because they couldn't afford attorneys either, and they didn't want to spend the time and energy. Also, judges in some courts around the country don't have a lot of experience in copyright. And the other problem is that juries can be unpredictable in terms of how they're going to reach a decision in a case. Those are some of the reasons that the CCB was created. When we were created, we have, limits about the kinds of cases that we can hear. Not every kind of case, even within the copyright field, can come before us. We can handle copyright infringement cases, declaration of non-infringement cases, which means that someone accused you of infringing their work and you want a statement saying from the tribunal that you are not infringing their work. The third kind is a misrepresentation claim, which is limited under 512F of the Copyright Act. It's a misrepresentation in an online situation where there's been a takedown notice or a counter notice. And all the legal and equitable defenses that you can use in federal court, including fair use, are available in front of the CCB. Some things to know, we cannot make an award more than $30,000. And we have something called smaller claims proceedings, where the maximum is reduced to $5,000, and the procedures there are hopefully more streamlined. And there's only one officer in that case making the decision. In all other cases, the 3 officers usually make the decision. So if for claims of infringement, what can you get? You can get actual damages and the alleged infringer's profits, which are caused by the infringement that you can prove. Or you could seek statutory damages, which are limits set by law. And that's set before the CCB at $15,000 per work if the work was timely registered. What does timely registered mean? Means that the work was registered before the infringement or within 3 months of the publication of the work. And that's what Jessica was talking about before: publishing the work, distributing it, selling it, licensing it, etc. If you were not able to register it within those timeframes, then the limit is $7,500 per work. And I will say, unlike federal court, where before you bring a case, you need to have the registration in your hand to file the case. before the CCB, you could have filed an application for the registration, and it could still be pending, but you could still file in front of us. And for the application to be pending, it means you have to have put in your application, your deposit copy, which is an example of your work. So if it's a photo, you'd upload a copy of your photo, plus the fee that's charged for the registration. Some people forget to pay the fee, or it doesn't go through, or they forget to upload the deposit copy. So those are important things to remember. And this kind of just tells you what kinds of cases we've seen thus far. We have quite a number of cases. We started for business on June 16th, 2022. And so far we have over 900 cases. The vast majority of them, as you see, are the 740 straight infringement claims. Some of them, overlap and have more than one claim in them. We have 10 where people just check all the boxes, which usually doesn't work. And we have, a good amount of misrepresentation claims, and then we have a small amount of non-infringement claims. And these are the kinds of works that the claimants are saying were infringed. A good amount are pictorial, graphic, and sculptural. We have a lot of cases involving photographs, but not all of them are. We have people that do murals and pictures and illustrations. The next category is motion pictures at 19%, literary works like books and articles, sound recordings, the actual recording of music or voice, and then musical works, which are the underlying composition, the lyrics and music that get recorded. And we have a smaller amount in other categories like dramatic works, software, architectural. Some people ask what unknown means or other. There's a box for claimants to check if they're not sure what kind of work they have. They could just check that box on the filing form. This shows you how many cases we've had. This is as of the end of July. We had 922 cases filed before us. So we have had, a good number of cases. Unfortunately, not all of them get all the way through, but we'll talk a little bit more about that later. And this shows you where the claimants are coming from. It's almost all over the United States, except for 4 states. And Tennessee is in the top 20. As of the end of July, we have 12 claims from Tennessee. So it's in the top 20, states where claimants are filing from. We also have international claimants from all over the world. I think we cover most continents except Antarctica. And something important to understand about the CCB is that while you can live abroad and be a resident of a foreign country and bring a claim before the CCB, if you cannot bring a claim before the CCB against a foreign resident, all respondents, or as we call them respondents, but you might know them as defendants in other cases, they have to be residents of the United States. And we have a lot of cases we end up dismissing because they're trying to file foreign entities or individuals. We also can hear cases against state or federal governmental agencies. It's another issue. I'm going to turn it over now to Whitney to talk a little bit more about the CCB process. I will tell you that our filing fees are, I think, quite reasonable. If you go to federal court, the filing fees are usually around $400. We initially request a $40 payment. And if your case then later on becomes active, we ask for another $60. So it's a total of $100 if your case goes forward. And I think I'll leave it at that and let Whitney take it over. Thank you.
Thank you, Monica. All right, so here I'm going to take you through what it would look like to have a claim before the CCB. I will talk about some general terms that we use to describe ourselves and describe our processes. I'll go into some depth about some major touch points within the process. So I'll go to the next slide, please. I'm going to start off. These are the big main takeaways. When you're thinking about the CCB process, we have on the left-hand column 4 things that you really want to think about and know about the Copyright Claims Board. First is that our system is voluntary. Claimants and respondents each have an opportunity to decide whether or not to participate in a CCB proceeding. Claimants do that the moment they file their claim, and the respondents get to do this during a required opt-out phase. As Monica said, we have low filing fees. So I will describe as we get into the process where that $40 filing fee comes into play and where that $60 filing fee comes into play. We have the ability to hear cases from the U.S. District Court. So if there's ever a copyright infringement dispute where parties have moved along in their claims in the federal system and have recognized the value of maybe streamlining their process and going straight to a decision, there is a possibility for us to accept those claims. And then kind of sort of initiating the initial phase and the active phase. When we talk about, so the initial phase and the active phase is a term that you're going to hear us use a lot when we talk about ourselves, when we talk about a CCB proceeding, because we think of it, you know, the initial phase is the vetting phase. This is the part where we decide, everybody decides that this is a claim that the CCB can hear, that the claimant wants to participate, and that the respondent decides whether or not to opt out. So the vetting phase is really 3 steps. First is the compliance review process. Second is the service phase where the claimant goes out and delivers papers to the respondent. And the third is that opt-out phase. That's the first half of a proceeding. The second half of the proceeding is what we refer to as an active phase. And so this is where we look at the, you know, we call it active because it's a very active process between the parties where you're engaged in dispute resolution. We'll go through some different options for dispute resolution. It can either be, you know, sort of a very stripped down proceeding that kind of looks like a litigation, but is not. Or we also offer a lot of settlement and negotiation services through the officers. So this is a flow chart for our initial phase. What you're going to see on the left, you have that beginning step where the claimant has decided that they want to participate in a CCB proceeding and they file a claim. Now, the second part is compliance review. This is sort of a cycle where the Copyright Claims Board reviews whether or not a claim is compliant. There are multiple opportunities to resolve any sort of compliance issues that are identified through the compliance review process. And then once a claim is compliant, we move into service. And then once the respondent serves, it has a choice whether or not to opt out. If the respondent chooses to opt out, then the claim ends, and that's all for the proceeding. Or if the respondent does not opt out, then we move on to the next part. So for from the respondent perspective, deciding whether or not to opt out is a weighing of a number of factors. There are a number of reasons why a respondent would want to participate with the CCB. First, you know, Monica walked through sort of our jurisdiction, right? The boundaries of things that we can and cannot hear. When a claimant brings a claim to the CCB, they are voluntarily acknowledging that they will be bound by the range of damages that the CCB can award, which is a maximum of $30,000 per proceeding, or another way to think about it is up to $15,000 for a work that's timely registered, or $7,500 for a work that is not timely registered. So for a respondent who is thinking about whether or not to participate, that can be that cap of damages can be, you know, a positive. There's also that lower cost. So the major cost of the proceeding itself, those filing fees are borne by the claimant and not by the respondent. So for what a respondent is looking at, there is limited discovery. There's no expert witnesses or depositions. So the exchange of documents and answers is something that is a minimum cost to both sides. A lawyer is not required. There's a lower risk of defaults. So if you're a respondent, and you know, we've gotten a couple of respondents who have been not sure about whether to participate, and they begin by not participating, and they start a default process. And there's a point where they've decided to come back in. The system allows us to bring respondents in and to hear their side of the story. Now, granted, we would love for respondents to participate the moment a claim goes active, because that makes it much faster and a quicker resolution for everybody. But the system is built so that there is a general disfavoring of defaults. We also do a close monitoring of bad faith actors. We have rules in place for both conduct and for a number of filings so that participants, when they come to us, that they are engaged in a fair, equitable dispute resolution. The copyright claims officers are all copyright experts, as Monica mentioned. And so what that means specifically for respondents. And so what Jessica mentioned in her portion of the presentation is she said, well, it's copyright infringement unless defense applies. And so for a respondent's perspective, they will need to evaluate whether or not there is a defense that applies to their conduct. And the great thing about having copyright claims experts hearing dispute resolution, a proceeding, is that they are all very aware of the types of defenses that can apply in a copyright infringement dispute. So they are extremely familiar with the law, especially with areas like fair use, which I think everybody, you see that in the news. Everyone has an idea of what that means, but with the copyright claims officers, they are experts and are able to apply those defenses in a more consistent manner with and sort of impartially throughout different copyright disputes. So for a respondent, and we get this question, why wouldn't you just opt out? There are many benefits that come with participating with the CCB. And the other thing is if the respondent does opt out, the claimant can bring their claim to federal court. So there is sort of, when you decide whether or not to opt out, it's not a question of, okay, well, how do I end this? It's okay, well, what is the next step? Is my next step going to be the CCB, or is my next step potentially going to be in federal court? Next slide. So we have two types of proceedings with the CCB. We have a standard track claim and we have a smaller claim. A standard track claim is essentially you come in, you file a response, parties engage in discovery, parties engage in written testimony, the CCB issues a determination. For the smaller claims track, it is much more of a hands-on process by one copyright claims officer. So for the one copyright claims officer, what they do is they gather facts from the parties. They issue a proposed finding of fact. Then after they hear from the parties about any objections to those proposed findings of fact, they issue a final determination. So the smaller claims proceeding, which has a $5,000 monetary limit, the idea there is that there is a more hands-on process where the officer is working directly with parties, build that factual record. For the standard track claims, the CCB is here to explain processes and procedures, but discovery is usually handled by parties themselves. So we have 55% with that standard track claim, a $30,000 monetary limit, and then 45% have with a $5,000 monetary limit. Next slide. So once we get into the active phase, this is what the standard claim active phase looks like. First, you have the respondent. So we hear from the claimant when they file their claim. And then we hear from the respondent that's the first step in the active phase. We hear from the respondent, they file their response. We have standard discovery, where parties exchange their documents back and forth according to a set of written instructions provided by the board. Then after those documents are exchanged, that forms the foundation of their written testimony. So what happens with the CCB is you gather your facts, you gather all of your paper, you gather all of your witness statements, you got, okay, this is the facts of my claim. You submit that to the board through written testimony. The board then will take in that written testimony and from both sides and may decide to hold a virtual hearing. In general, we've held virtual hearings on factual matters or to develop a factual record based off of specific issues. And once the copyright claims officers, they have the factual record together, they issue a final determination. Now, this is sort of the trajectory for a general standard active phase, but know this: settlement can be accomplished at any time. The officers will always note when settlement is available. They will encourage it if it feels like the parties are open to it. So settlement can be requested by the parties at any time and can be facilitated by one of the officers. Next slide. So this is our progress of active cases by the numbers. So, we've had over 900 claims, 149 of those have gone active, and 40 of those are currently open. For those 149 total cases, 72 responses were filed, and 8 are currently in that written testimony phase, so they're nearing the end of their journey. For default, we've issued 46 first default notices. So that's the moment where a respondent usually fails to file a response, fails to attend initial conference. So it looks like the respondent has decided to not participate. That's when we'll file our first default. And then for settlement, we've had 16 settlement conferences, and we've had really good success settling 8 of them through the active settlement conference phase. Next slide. So stepping back, we get a lot of questions of like, how do claims, if not through the final disposition, final determination, how do our claims end? So our claims are usually dismissed, 365 of them are dismissed during compliance review. And so there's a combination of why a claim might be dismissed during compliance review. It's either, we have found that a claim cannot proceed, or a claimant has decided to not file an amended claim. We have 144 claims where the claim was compliant, but the claimant didn't file a proof of service. In 150 claims, we've had a request to withdraw. And in 75 of those cases, we've gotten affirmative confirmation that the parties have settled. And then we've had 88 claims where the respondent has opted out. So we talked a little bit about the second half, the active phase. I'd like to circle back. I'd like to walk us back to that initial phase and talk about compliance review a little bit in depth, because if you decide to be a claimant before the CCB, compliance review is going to be the first process, your first step to work through. So I'd like to talk a little bit about what that process looks like and some common issues that we see that can be addressed before you file a claim. Next slide. So just to step back, our big picture is, 450, about, over 50%, a little less than 2/3 of our claims are ultimately found compliant during compliance review. And then as 365 claims that have kind of been dismissed, either because we don't have an amended claim or because we find that the claim just cannot move forward. To go into depth about our compliance issues, with infringement, we've noticed trends for both our infringement and misrepresentation. For infringement claims, let's start with some of the low-hanging fruit. Let's start with a couple of the infringement compliance issues that we've seen that can be addressed very simply, very easily, right away before a claim is filed. The biggest one is registration. So Monica mentioned that we are very flexible on our registration requirement with the CCB, but there does have to be the application, the filing fee, and the deposit into the office before the claim is filed. So if we have those 3 things in place before the claim is filed, then that claim is compliant on the registration requirement, and it can move forward on that ground. So for us, in terms of one thing that we see with our infringement claims, infringement compliance issues, registration is a big issue that we know that can be addressed and can be a non-issue very easily by submitting that information. So when Jessica joins us back in the presentation, she'll give you some resources that will help you, that help people decide how to submit a registration application and get that going. The second thing is legal or beneficial ownership. We see this a lot if you are in the audience and you are someone who has a small business, and that's maybe how you distribute your creative works. Know that your small business and the way that you do business is often separate from copyright ownership. So if you are still the copyright owner in your works, you will want to file a claim in your own name rather than in your business's name. And so that's something that we write on. It's pretty easy to fix, right? Because the claimant goes back and they, separate out, okay, well, what's copyright ownership here? Great, legal beneficial owner, done. Access and substantial similarity is something that can be, so access and substantial similarity are 2 sort of foundational concepts for copyright infringement. We need to have some information about how the respondent may have accessed your work and what the substantial similarities between your 2 works are. Now, if you are in a scenario where the work was copied almost wholesale, to provide that information to describe how the works were copied wholesale, it says 100% copy, describing it or showing it through the copy itself and the infringed work, that resolves the access and substantial similarity question very quickly. If you are looking at where someone has adapted your work without authorization, they're providing a description about how those works are similar, or how the respondent came to have your work so that they could adapt it. That's where access and substantial similarity, having those descriptions in there is important. For misrepresentation, just a note that misrepresentation is a very specific question. Misrepresentation has to be about copyright. It has to be in a notice or counter notice. Respondent is party, and the harm has to be due to misrepresentation. So for here, the thing with misrepresentation is I would recommend, if anyone thinks that they may have a misrepresentation claim, read our handbook first, because misrepresentation is a very technical type of claim and has to have all of these factors satisfied before filing. So where, with infringement, there are some quick fixes that you can make to avoid compliance issues. With misrepresentation, because it is a technical claim, the recommendation here is to really go to the handbook, read the resources, reach out to ask the board, and get some assistance to find out more about the requirements of a misrepresentation claim before filing. Next slide. All right, so at this point, I'm going to pass it back to my colleague, Monica McCabe, who will talk about our CCB Pro Bono referral program.
Thanks, Whitney. Before we go on, one thing should have mentioned up front. All of our conferences and hearings are virtual. No one has to come to Washington, D.C. to present their case or to defend their case. Everything is done online on Zoom, so that it's very easy for parties to, to connect in, and we can hear the case. So that's another benefit of being before the CCB and not having to go to a physical court. Anyway, moving on to pro bono referrals, I wanted to give you a little bit of information. Next slide, please. So to combat some of the problems that, non-lawyers have filing claims, I mean, some of the terminology and just the whole process can be overwhelming sometimes. You can seek assistance from organizations like the one that's presenting this seminar. It's the Volunteer Lawyers and Professionals for the Arts. Is on our list, and we have a list of organizations and law schools where students are willing to help parties either at little cost or no cost at all, which is, meaning pro bono, as we call it in the legal profession. So there's different kinds of levels of representation that you can have. Sometimes you just go and speak with a lawyer or a law student on a one-time basis, and they'll tell you what you need, if you have a valid case or what your defense could be, and you go take this information and then you go either file your claim or defend your claim, depending what side you're on. There's also advice and guidance about handling files and conferences and hearings themselves, where the lawyers or the law students are in the background and you file everything and do all the hands-on stuff, but they're giving you information as you go along. And then finally, there's, some law students, clinics, and pro bono attorneys are willing to do the whole thing. They kind of represent you. They attend the hearings and conferences. They fill out the forms, etc. So everyone should be aware that there's different levels of participation by attorneys. Sometimes you just need help with your registration, and you can seek someone out for that. Next slide, please. So as you can see from this slide, the vast majority of our claims have been filed by self-represented people, not lawyers. Some do have lawyers, some use an in-house attorney or some kind of company representative like an officer, a director, employee. And we have two where the claimant was represented by a law student. We also have some respondents that have been represented by a law student as well. So this is just a copy of our webpage, which is at ccb.gov. We'll talk more about that later on. And this tells you where to go for our pro bono directory. And it kind of explains a little bit of what I was saying about the levels and the two kinds of organizations that are willing to do pro bono work for participants before the CCB. If you look in that blue box there, you'll see the link to where you can, the exact page. But if you go on our first page and go into lists and directories and go down to the drop down, you'll see pro bono directory. Next slide, please. And this just shows you where we have our law student representation directory. And then underneath that, we have all our pro bono organizations, including the one, as I said, that's putting on this presentation today. So some of the resources that we have to help people, kind of navigate their way through, in addition to, possibly getting a pro bono attorney, is everything is filed online in the system we call ECCB, where, it's a fillable form that you go on and fill out and then you submit. And you can register if you're a participant, and that's how you'll receive, file, and get orders, information, etc. People should be aware that anything filed there that's not on unrestricted view will be viewable by the public. And anyone can go on and do searches. For instance, if you were going to file a claim and you wanted to search other cases to see what people filed or how we came out in them, you could do your own searches on ECCB. Service is an issue. It's difficult for some parties because you just can't take your claim and stick it in the mail and that's adequate service. There are particular rules under each state about how the respondent has to be served. Some companies and entities have what's called designated service agent database, which means they list who is supposed to get their legal documents, right? So you would go on that, if you're going after an entity, you'd go on that list and see if they've designated somebody and an address where it should be served on. And this is the address here, agentdirectory.ccb.gov, where you can do a search and see if the entity you're going after is on that list, and then you have to serve them through that person or that agent they list on the list. Next slide, please. And this is just a kind of a little snapshot of, our ECCB system. If you're going to file a claim, we have like instructions here. There's little I in a circle boxes. If you want more information, you can click on those. And, as you go along, you save and continue. If you get interrupted, and you can just save it and go back to it later. So it's a fairly easy system where you just fill out certain portions and answer questions as you go along. Next slide, please. And this is where the respondent would go to file their response to the claim and list out their defenses, etc. And it's the same kind of situation where it's a fillable form, and there's little I's where you can get further information. Next slide, please. And this is if the respondent is going to opt out, there's a special code they have to put in here. And if there's more than one respondent, each one has to have their own code, which is in the packet they get when they're served. And it's just a page they file and submit, and then they're done, and the case will be dismissed. Of course, as Whitney said, the claimant can always go and file it in federal court if they want. Next slide, please. So these are some of our resources that we have on our website, which is, as I mentioned, ccb.gov. There's a portal to ECCB, so you could just click right on one of these blue buttons here, and you'll get right into ECCB. There's also a link to this DSAD, as we call it, the Service Agent Database. Libraries and archives have a special opt-out where they can preemptively opt out of cases. And if you're going after a library archive, you should check that list to make sure they're not on it, because they're automatically opted out. And then, as Whitney referred to, we do have a handbook. It has 23 chapters, and highly recommend you're taking a look at it. It's broken down in pieces, so you don't have to read the whole thing at once. But if, let's say, you're filing a misrepresentation case, go to that chapter about filing a misrepresentation case, and it'll give you a lot of information. There's also other educational resources on our website, like little videos and other information and graphics that hopefully will help you along in the process. Next slide, please. And now I'm going to turn it back to Jessica to go over. She's going to go over some of the other resources offered by the Copyright Office.
Yes, thanks, Monica and Whitney, for that wonderful overview of the Copyright Claims Board. So as they mentioned, that's one very important component of the office and what we do. But I just wanted to talk a little bit more about our other duties and make sure that you guys are aware of the work that the Copyright Office does day in and day out. So just a little bit of background, the Copyright Office was founded back in 1870 within the Library of Congress, and we are the main United States agency that administers the Copyright Act. Again, that's Title 17 of the United States Code. And as part of the Library of Congress, of course, that means that the United States Copyright Office is part of the legislative branch of government, not to be confused, of course, with our peers over in the executive branch, or the Executive Agency Department of the United States Patent and Trademark Office, which administers our trademark and patent laws. We are in Washington, D.C., and we, of course, administer copyright law. So that's a large statement, and we wanted to just kind of break that down. What does it mean to administer copyright law or the Copyright Act? That does entail a number of different roles and responsibilities. At our small office, we're a staff of about 430 that we do. And so in general, the list on this slide summarizes the work of the Copyright Office today. So we create and implement regulations, we make and maintain records, administer statutory licenses, and advise Congress by providing legislative support, responding to member and staff questions, and participating in hearings, providing trainings to Congress as well, just as they're needed. We do the same on an international level by interacting in the international copyright community, including with our executive branch agency colleagues. And lastly, but very importantly, we provide information to the public, including through presentations like this. But that's kind of what I'll focus on in the next few minutes or so, is just the resources available to you. So Whitney mentioned how important registration is, and I wanted to spend a minute talking about copyright registration because it is a big component of what the office does. So as you're working potentially with VLA attorneys and professionals, you're likely going to be asking questions about this. And so these are a few important basic notes for you on registration. Number one, it is voluntary. So many people think that registering a work with the Copyright Office is what's required to have that protection. But again, we mentioned in the beginning, it's fixation. We're talking about original works of authorship that are fixed, and copyright protection begins the moment that a work is fixed. So you don't have to register with the Copyright Office. But that being said, there are some really important benefits, legal benefits, and that's why we strongly encourage copyright registration. Importantly, it's a prerequisite to filing a copyright infringement lawsuit in the United States. So we're talking about access to both the federal court as well as the Copyright Claims Board, although both Whitney and Monica mentioned that in order to start that proceeding with the CCB, you just need to have submitted. You don't have to have a registration completed. And timely registration can also provide access to statutory damages, attorney's fees, and establish that prima facie evidence in court that you do have a valid copyright. Importantly, and we'll talk about the public record in a minute here, registration does create that public record that includes key facts about your work, such as, who the author is, the owner, and publication details. And importantly, it provides information to potential licensees. So those folks who want to contact you to obtain permission to use your work or to make copies or to use it in their own. Lastly, registration needs to only occur once for each work. You don't have to renew your registration. You do not have to re-register at a later date. And the Copyright Office is the sole administrator of registration in the United States. So we are that author's authoritative resource on copyright information and the one administering the registrations here in the US. These 3 points were mentioned by Whitney and Monica, so I'll only spend a few minutes here. But what does it take to have a completed registration? Well, first, you have to have submitted an application. There are many different types of applications, dependent on the types of works that you're trying to submit, as well as the number. So I think we got a question before the webinar about how can I register hundreds of works? So I'll cover that right now. Essentially, registration is a fairly simple, straightforward, affordable process. Aside from that, application package, which consists of the application form of your choosing, and then the deposit, which is the copy of your work, and the filing fee. Something important to keep in mind is that the fees can range. There's a general rule that you need to submit one work by one author, on an application. One work on one application. And so in that regard, the cheapest application option is $45, where it's one work created by one author. But that's just the general rule. And so the office has created a bunch of what we call group options or accommodations where you can submit more than one work on one application. So for example, we have a group option for photographs, both unpublished and published photographs, and that one accepts up to 750 photographs on one application. So again, that's one filing fee. But it'll depend on what you're trying to register, what kind of work you're interested in registering, and each application option will have its own eligibility requirements. So we're not talking about 750 for each. Sometimes it's just up to 10 works that could be registered. But we encourage you to take a look at our website and call us for more information on that, which is really what I'll spend the last couple of minutes going over, how to get in touch with us if you have questions. So the CCB highlighted their website, of course, the ccb.gov, and of applicable resources as you're navigating that process. But to highlight the broader resources available to you, first and foremost, we do have a public information office. PIO is the acronym there, and they handle phone and email inquiries from the public. So you can call them like a call center. They are real people answering the phone and these emails every day. So you can also schedule a walkthrough with these folks if you have questions about what type of registration application to use, or if you're in the electronic application trying to figure out how to navigate it. One thing I didn't cover on the previous slide is that you can submit a paper form if you'd like, but we strongly encourage you to submit that electronic form online because it's usually a faster process that way. So the website for you to contact our public information office is copyright.gov/help, and you can again schedule a walkthrough appointment there. And then separately, our outreach and education division kind of plans and prioritizes public programming, including subject-specific presentations. So you can reach our office if you're interested in scheduling an event such as this one, a presentation, and use our speaker request form. That's found at the second link here on the screen. And aside from presentations, our outreach and education section also develops a number of publications and online resources, which is a primary, reason that you're here today. So I'll highlight these two very important resources if you're interested in learning more about copyright foundational basics, as well as policies and practices of the office. Circulars. Circulars on the left are a narrative resource highlighting concepts of copyright law, policies and procedures of the United States Copyright Office, including our registration practices. There's a circular on works made for hire if you're interested in learning more. And select circulars have also been translated into Spanish. So you can visit the webpage on the left to kind of find the accompanying link for the Spanish resources if you're interested. And then on the right, we have the compendium. So the compendium is an instruction to Copyright Office staff regarding statutory duties, and it provides expert guidance to applicants such as yourselves, practitioners, scholars, the courts even reference it, but just members of the general public can feel free to navigate this resource and understand more about our institutional practices. It is a living administrative manual in that sense. So it's continually being updated, and we do announce when those updates happen so that the public can kind of keep up to date with practices and practice changes. So I mentioned the benefit of copyright registration being creating a public record. And so the Copyright Office is an office of record. And what that means is that you can search registration records to find prior registrations made with our office. One of our strategic goals right now is what we call continuous development. And on that front, what we've done is developed a exciting new searchable card catalog of all of our records that are included in what we call the Copyright Public Records System. The acronym we use there is CPRS. So CPRS is in its pilot, but the office does continue to develop it so that users have this kind of single, easy to navigate, highly searchable database of Copyright Office public records. And the pilot does not replace the official online public catalog, which is available at the second link here that you see. But when accessing CPRS, you'll notice that it's very different. It's very advanced. There's different search interfaces that you can use, such as query builders and filters to kind of make your search easier if you're trying to research the copyright status of creative works. So it could take an entire presentation to walk you through how to use CPRS. And so what I'll do instead, because we want to make sure we get some time to address your questions, I'll point you to the tablet on the far right here. It is highlighting our August 1st webinar that we hosted It was called Level Up Your Copyright Public Records Search. And what the whole webinar did in 1 hour was walked participants through different ways to search the CPRS pilot. So it did include that live demonstration, if that's what you're looking for, you know, of CPRS's powerful search capabilities, and also included information on additional research and support services that you might want to look into if you're interested again in searching our records. So a recording of that webinar, August 1st webinar, is now available on our website. So please check that out there. Again, that's copyright.gov. In the middle, I'll just focus on for a minute our Learning Engine video series. These are just audio visual form, you know, learning resources on copyright concepts in its entire series of videos that cover things from the public domain, fair use, to the CCB. There's an entire video on the CCB if you'd like to kind of get that introductional information again. And then on the far left, we have our Engage web pages. So we love our Engage web pages and talking about them because they're very focused on specific creators. So we have Engage web pages for writers, musicians, photographers, and then visual and graphic artists. And what we've done is compiled resources for all of those creators in those specific industries to kind of be able to, again, navigate that copyright system and the copyright information associated with their work regularly. So for updates from the office, you can subscribe to our Newsnet. That's our digital newsletter. You can follow along on our events webpage. It's just copyright.gov/events. We also have a blog. It's called Creativity at Work. And you can subscribe to various kind of subscriptions offered through the Copyright Office, including music-focused ones such as the MMA, the Music Modernization Act, or the Copyright Royalty Board. They all have updates that are kind of focused that you can subscribe to specifically. And then lastly, of course, we encourage you as always to follow us on social media. So we do have an active presence on X and LinkedIn, and we post, you know, news and announcements there as well. So with that, I wanted to make sure we leave at least a couple of minutes here for questions. If you have questions after today's presentation as well, you're always welcome to direct them to the email addresses or the telephone numbers that you see here. For the CCB, that's going to be asktheboard@ccb.gov. And if you have a general copyright question, that's going to be copyinfo@copyright.gov. But I think I'm going to turn it back to Kate, who's going to walk us through maybe some of the questions that we received in the chat. Thank you.
Thank you, Jessica. The first one is individually created Foley covered? Foley, like sounds that you make during a movie, like Foley actors?
Yeah, so they're like they're sound effects, right? So like all the crunching that you hear of like the leaves in the movies. And so so Kate referred to Foley artists who create the sounds that go with the movie itself. So Jessica, I was going to have you answer that because that one seems like a tricky, what's part of a motion picture as a proper work and what's an independent work?
Sure. So I mean, when we talk about those types of works that we talked about, for example, sound recording is one, and Monica mentioned as well, it's the recording of sound. And in that way, we're not talking about sound accompanying a motion picture. So a motion picture does include many different elements, including that soundtrack. And again, yes, you're looking at both elements there of copyrightability, so that independent creation and sufficient creativity to analyze whether it's protected by copyright. I think, Kate, that was ultimately the question, was looking back at independent creation and those sound effects.
Yeah, and then the person added a little more information. They said Foley artists sometimes sell their sounds they collect.
I mean, I think we just mentioned that, you know, once you have that original work of authorship and it's fixed, you have the exclusive rights to do what you want with the work, including to distribute it to the public by selling it. And so that sounds like an avenue that someone has taken there or is interested in taking, and that's great. Thanks.
Awesome. And then another question we have is that someone took a photography class, and the class said that it's important to copyright their photos, and they have thousands of photos. Which ones are important to copyright?
Great question. I think it's always, you know, a business and kind of legal decision to decide what you want to register. Keep in mind that the copyright protection does exist the moment that you created those photographs. So maybe what you end up analyzing is which photographs are being stolen or being copied. And that's that legal risk that you might want to consider as you consider what to register and where to spend your money. But of course, we mentioned the group options with photographs, especially the group option that can range up to, submitting up to 750 photographs in one application with one fee. So that's another consideration that you might.
I would just add also that you might want to consider which photos are publicly facing. So if you have a website where you maybe license or sell stock photos, you definitely want to cover those because they're accessible to the public, right? So anything that might be accessible to the public where somebody could, potentially copy it would probably be the ones that you want to protect first if you couldn't protect everything, just because those are the more likely ones to be infringed, I think.
Great. Does anybody have any more questions?
There's a question I see about how far back does the search go, Jessica, in terms of searching Copyright Office records?
Oh, yeah. I made a note for that in case anyone had that question, but the official online public catalog that I mentioned contains records of copyright registrations and transfers of copyright ownership that were created after that January 1, 1978 date. So it's January 1, 1978 to the present in our official online public catalog. And then pre-1978 records, those are records created between 1870 and 1977, are searchable on site in the Copyright Office in Washington, D.C. And just for your awareness, that card catalog has been digitized and it's in its proof of concept. So it's called our virtual card catalog, but it's again kind of in that pilot stage. Hopefully that helps with dates. So that January 1, 1978 date is critical in copyright law because it's when our Copyright Act became effective.
I have a question, if you allow me.
Yeah, go ahead.
First of all, thank you so much for one of the greatest webinar in my life, because I have been trying to launch my business, but the copyright laws and the complications that faces me is making me not be able to even go ahead and post anything, because I'm really I am confused in regards to what to do for the work that I would like to publish for the public. My goal is to help people, see my vision the way I see it, and it's not about the money. But if it makes money, that's something that is good, because I've resigned my job to do this job. So one of the things that I don't understand is when you say you own that piece of work, whether it's an artistic work, whether it's in a published form, where it's like a food recipe or something else, a picture that you've taken, what considered is yours, that is, you are the author? What if somebody else did the same thing but you did not know about that person? Are you the owner and the author of that product, or whatever form that thing that you are claiming ownership to, or the other person is? And also, what is considered copyrighted in regards to pictures? If you take a picture of something that is belong to someone else, for example, like there's public and private things, do you own ownership of that picture and you can sell it to the public and it's yours without the permission of the owner of that building, for example? Like some things, also food recipes, like I don't know who owns the food recipes, like, because there's a lot of food recipes, especially the historic ones. I can't contact.
I can interrupt just 1 second on that question. Unfortunately, recipes are not copyrightable. I had clients in the past in my prior career where, they had elaborate recipes they came up with, and unfortunately they're not protectable. If you have a blog or you have a picture and you give some background and history of the recipe, and then the recipe, parts of that can be protected. Like, what you're writing, and the photo itself can be, of the food, for instance, could be protected, but the recipe itself is not protectable.
So if the food recipe is in a government website, for example, I have an example of a food recipe that is from the 15th century that I found in a Fairfax County, I think, website. And I would like to share that recipe for the people to know about, the history. I would like to be like a tourist guide for the DMV area. That's one of the things that I would like to do. And I want to do it in a way that is not so historic. So I want to do those historic recipes, but in a way that I'm like dressed up modernly, like, I'm not like dressed up in the to attract younger viewers, to make, to become more trendy. And one of the visions that I wanted, one of the things that I've seen on the website that says, we took this recipe by permission. So does that mean I'm not allowed to copy that recipe from that website and share it on my site for the people? And since that recipe is historic, what elements of that, article in that website that I can use, and does that give me the copyright or give them the copyright? And that confuses me, because everything that I'm going to be publishing, I will have to search it online somehow in all the websites and books and libraries and other forms. And then I will come up with my own form of an article. But what is in that article that is mine and copyrighted to me, and what does belong to all the other people? Because that's what confuses me.
Yeah, since we're limited on time, I'll just mention
Yeah.
that with independent creation, theoretically that does mean that two works could be identical, but what the copyright law is concerned with is whether or not that work originated from one person. And it could, again, there could be two works that are nearly identical or identical and still be considered independently created if each of those individuals originated that work. So that's just one thing I wanted to touch on independent creation. And then you asked about photographs and the subject matter of photographs and what's protected there. So a key component of photography and copyright law is that it does not depend on the subject matter. So the photograph itself is when you click that capture button on your phone or on a camera, and it depends on who is doing that action, who's taking that action. That's going to be the photographer. It does not rely on the subject matter behind the lens. And so therefore, Monica, Whitney, and I could all take a picture of the Copyright Office, and each of our photographs is going to be, independently created and hopefully sufficiently creative. Whitney, did you have thoughts to add there as well?
Oh, I was just gonna tie everything back to the Copyright Office resources. So in listening to, your project and what you're thinking, there are questions of, concepts of copyrightability. And so like there's a circular about things that are not sufficiently protected. I think that there might be a YouTube video too about things that are not sufficiently protected. There's like background information. Part of the not sufficiently protected sort of some of the principles that Monica discussed about recipes. So like what about a recipe is protected? What part of a recipe isn't protected? What part of the photographic material or explanation around it would be protected? There's some background information and circular on that. And then I think that there was a question about, very old recipes. And so I think that the Copyright Office has some resources on the public domain that could be helpful for background information too.
Yeah, after a certain time, copyrights expire. Currently, it's the life of the author plus 70 years if it's not a work for hire. But in the past, the copyright extensions were shorter, much shorter periods of time. So it depends when it was created, whether it's in the public domain. You have a complicated issue because if you have an old book that has a recipe in it, it may not be the recipe that's copyrightable, but the book itself and how they present it is copyrightable. That's their particular work. You may take the same recipe and present it in a different way, and that what you add to it can be protected.
But I'm allowed to use it though without the permission of the owner of the book.
Well, I would not get into, I wouldn't, we are all lawyers, but none of us can give advice. So, right. So the awkward pause that you hear from Jessica, Monica, and I are all the, where we can't say like, yeah, from that book, absolutely take it, because we're not going to get that. But what we're going to do is we're going to tell you, okay, the Copyright Office has a bunch of resources about these concepts of public domain and copyrightability, and you can take a look about that. You can take a look at those resources. And then, Jessica mentioned that there are ways to, reach out to the Copyright Office for more information. So we can't give legal advice. Our Kate and our friends over at the VLA may have some resources or opportunities there for you. So like, you're definitely looking, you've got a wealth of resources for you to review, take a look at, and then kind of, step back and evaluate your strategy there.
Thank you so much. I really appreciate it.
Well, awesome. Thank you, Jessica, Monica, and Whitney, for an incredibly informative presentation. and to the Copyright Claims Board and the Copyright Office for partnering with us on today's webinar. The team at the Arts and Business Council is dedicated to providing the highest quality educational content possible for our creative community. Help us continue to improve our programs by completing a short survey about today's webinar. You'll find the link in the chat. Give a big thank you again to Jessica, Monica, and Whitney. This was really great, and we appreciate your time. And then I just want to give a reminder, a link to the recording of this session will be emailed to you within 7 to 10 business days after this webinar. And in the meantime, you can download the course materials using the links in the chat. Yeah, thank you so much for everyone for attending today. I hope you all have a great rest of your day.
Thanks for having us, Kate. It was great
Thank
you.
to
you.
do this. Bye-bye.
Thank you so much.
Thank you.
Bye.